Fast forward any come watch on so ha age politics avenue. Podcast stories are trending because making headlines and we aksumu. Yomon Ryan Simu. Chief Justice Torkonoo's remover. Or the same akodan a year ECOWAS court say omo enkebi emano. Sense we see na bidya for attraction omo eyemu pinsim mu. Mestre say yomon rem ne hwene yako ani de ba.
But let's start off from there, right? The default judgment now being sought by the former and now dismissed Chief Justice Gertrude Torkonoo. What do you make of that?
Yes, good afternoon. A default judgment is part of the legal process. It's a procedure that when you file a case against a party, that person must respond within a stipulated period specified by the procedure conducting the court. So, in effect, she may go for a default judgment, but the nature of a default judgment is not a final judgment. A default judgment is not what we call a final judgment because all parties have not been heard. So when you obtain such a judgment, it may not constitute a final judgment. A feature of it is that it can be set aside within reasonable time by a party who is affected by it. Having said that, I'm wondering what is the nature of the relief she's seeking at the ECOWAS court. Is she seeking a relief that will end up abrogating or rendering void what has been done in Ghana? I believe not. Our constitution, when it comes to a conflict between an external law and our internal law, like the constitution, will take precedent over an external law.
The external law, Musa, now that she's been dismissed,
yes,
she's been removed as Chief Justice. Even if there is a default judgment, what impact could it have?
Well, that's why I asked the question, what reliefs?
Well, we know she's seeking some damages as well, apart from, the process itself. She is seeking
some. She talked about violation of her rights and all that.
Absolutely.
Right. That may be independent of what has taken place in Ghana. That may be different. If she's seeking damages in relation to abuse of her right, her constitutional right, her freedom to seek justice and all that, you are looking at a different set of reliefs independent of this. So the impact may not be, one cannot say is going to be negative.
Right.
One cannot also say with certainty that it's going to be positive. It depends on how the ECOWAS court is going to look at it. And as lawyers, normally we don't prejudge a decision that is before a court of competent jurisdiction until the court has made its final decision known. So at this stage, I will not make a definitive
But Musa, what does it say? What does it say of Ghana when the AG has failed to put in that defense within the 30-day period? What does it say about how Ghana is treating the case of the ECOWAS court?
I don't have the facts at hand, but if a party believes that a court has no jurisdiction, for instance, the party may do one or two things. The party may decide to ignore the process that has been served on it, or decide to file another process to challenge it. I do not know the reason for which the AG is alleged not to have filed anything, but I think I will need those facts to be able to justify my conclusion on that matter.
I see. But let's look at another issue that has come out surrounding this, right? We know that the former Chief Justice as well, Sophia Akuffo, has faulted the process. For her, the removal of the head of the Judicial Service or the judiciary is an affront to the judiciary, and it weakens, in her words, it so weakens the judiciary. Do you hold the same view?
Well, I don't hold the same view. That is a personal view. Even when she sat as a justice of the Supreme Court, eventually became a chief justice, there were many times that she sat on a panel with other judges and she dissented. Other justices also dissented from her view. So her singular view cannot be seen as overriding the decision that has been taken. You understand? It's just like a coin. The case is like a coin. You have other parties looking at it from the other angle, and what they see there is not the same as what the other parties are seeing from the front. So I would say that much as everybody has his own opinion about some of these cases, we should not accept as a kind of overriding decision because she was a former Supreme Court justice, she was a chief justice. We respect her for that, but her opinion does not constitute what the law says.
Very well, Musa, we'll leave it here. Thank you so much for talking to us. Musa Ahmed is head of Ahmed Legal Consult. We've just been discussing the latest development around two former chief justices, really, Gertrude Torkonoo and Sophia Akuffo. You're here on News Central. We'll take your time. Well, that'll be all from your election command center as we bring you, keep an eye, really, on Akwetia. Gertrude Torkonoo is urging the ECOWAS court to deliver judgment in her favor, insisting the Attorney General has failed to file a response to the case within the stipulated time. Her lawyers today filed processes alleging the 30-day timeline provided in the rules for responses to be filed has not been complied with by the country. Let's take a closer look at the reliefs the former Chief Justice is seeking from the court in this fresh move. We know that on the first case, she says an order of this honorable court, which is the ECOWAS court, entering a default judgment in this suit in favor of the plaintiff or applicant, former CJ, due to failure of the defendant respondent, which is the government of Ghana, i.e. the Attorney General, to file a defense. And for such order or any other orders as this court may deem fit, right? But what really are the reliefs that former Chief Justice Gertrude Torkonoo is seeking? Her main concerns include the court's rules requiring responses to cases to be filed within 30 days. The Republic has failed to do so. This means that the Republic has abandoned the case, has not shown any interest, which is why she's asking that the ECOWAS court rules in her favor. Meanwhile, former Chief Justice Sophia Akuffo has condemned the manner in which Justice Gertrude Torkonoo was removed as Chief Justice of Ghana, warning the act, which she describes as unjust and deeply troubling, will serve as a bad precedent for the image of the judiciary.
I'm very sad about it. It has really saddened me. And maybe in a way, I feel very distressed by it. Yes.
Mm. In terms of the conclusion that was reached, where the matter has journeyed from, is the sadness as a result of the conclusion, or you have questions about the procedure that took place before that?
The sadness is about the whole process. My sadness is because, as far as I'm concerned, it was a very unnecessary. We have been taken through a very unnecessary situation, and which, as far as I'm concerned, and that is my honest and candid view, this has so weakened the institution of the judiciary. It's not so much the individual who occupies their position. It is the institution. That is what I'm concerned about.
I mean, what informs the conclusion that it's an unnecessary process? I mean, we have heard even government spokesperson make the point that a petition was sent, a committee in line with the constitution was set up, they've looked into the matter and they've come to a conclusion. Which aspect of it, what specifically makes that necessary?
I think that, you see, there has always been something wrong with Article 146. And particularly with the procedure that it sets out, and especially as it regards the position of the Chief Justice. In the Ajaychum case, I took the opportunity to reflect on that weakness that I noticed. And are these, and these are not so to me, they lack the gravity. They lack the gravity that would lead to a grave outcome, such as the removal of the head of an institution of justice. I've deliberately phrased myself that way. It trivializes the position, and I wonder what this is going to lead to further on along the line, because every judge is fair game and every Chief Justice is also fair game.
I mean, is that to suggest that you suspect there could be a ripple effect in that?
Oh, definitely.
Any matter?
It's not suspect. I foresee. Not tomorrow, maybe not next year, maybe not in 5 years' time, but along the line, yes, unless those provisions are dealt with effectively in a revised constitution.
Maybe a more direct question. I have seen the letter that was written by the Secretary to the President to the former Chief Justice.
And that's the other thing. A warrant, a person holding a presidential warrant, that's what the position is. You become Chief Justice because you have received a presidential warrant. You can receive all kinds of letters that you are hereby appointed, but if you don't have that warrant, does that make you Chief Justice? Yeah, okay. So if you're removing the person from the position, is it a subordinate who signs the letter? Is that the way it's supposed to be done? That's just by the way. Food for thought.
Yeah, but I've seen a warrant as well signed by His Excellency the President.
So why are they showing us that one? I've been receiving all kinds of messages, and every one of them is only bringing out that letter. And in any case, is it polite? Is it proper that it should be a subordinate who writes a letter of removal to a Chief Justice? Really? Really?
Let's unpack all the issues. Joining me now is former director of the Ghana School of Law, Kweku Ansah Asare, who holds a rather interesting view on Justice Sophia Akuffo's decision to go public with her views on this particular matter. Good afternoon, lawyer. What really is your position on Justice Akuffo's, who is a member of the Council of State, her interview with us and letting us know what and how she feels about the removal of Chief Justice Torkonoo?
Thank you very much, and good afternoon. I'm not going to comment on the substance, of what she said. But all I can say is that our eminent and distinguished former Chief Justice of the Republic of Ghana has nodded a little. the public has reposed confidence in her. She subscribed to the oath of the member of Council of State and the oath of secrecy. So her comment, the whole interview is inappropriate because having subscribed to those oaths, to realize that she cannot reveal or divulge anything. And some of the things she said, just came directly, from her knowledge, knowledge of what actually, transpired at proceedings of the Council of State and their appearance at the committee. Once she has subscribed to certain oaths, she must always bear in mind that the oath is a sacred duty, which must not be broken. What she has done is in clear breach of the trust the good people of Ghana have reposed in her. That is the comment I'll make. And it raises issues of governance, confidence, and trust in persons, who, are the helm of affairs and who are the limelight, of the nation. She speaks as, one of the consciences of the Republic of Ghana. And my good advice to my distinguished former Chief Justice is that in such matters, she should remain silent.
I see.
In view of the oath that she has
how would you
subscribed
react to the argument that really she didn't divulge any secrets? She only gave her opinion on the matter.
The oath of secrecy. The oath of secrecy is that, when she subscribed to, is that she will not directly or indirectly communicate or reveal to any person any matter which shall be brought under her consideration or shall come to her knowledge in the discharge of her official duties, except as may be required for the discharge of her official duties or as may be specially permitted by law. So what they do is not permitted by law, it's unwarranted. And my advice is that our governance experts should abide by the tenets of the Constitution in the name of good governance.
I see. Let's look at some of the substantive matters that she has raised in that interview with us. Again, she talked about the procedure. She felt that in the last bits of that interview,
commenting on whether it was appropriate for her as a member of Council of State to grant the interview in the one-on-one with Dr. Akuffo show this morning. I'm saying that we are watching, we are following her, and that's followers. She should be able to carry us, along in accordance with the Constitution, but not to do anything, which will set bad precedent, for those of us following.
I see. There have been calls for her resignation. Do you support such calls?
Who should resign?
For Justice Sophia Akuffo to resign from the Council of State?
Well, that's entirely, she owes her membership of the Council of State to the Constitution, not to the President. The Constitution states a former Chief Justice, so only the Constitution can remove her. Only the Constitution can remove her. She is speaking her mind. What I'm saying is that she is inappropriate. She shouldn't have done that. So it's up to her. It's a moral issue. Up to her to decide whether to resign or to remain. But, her position now, seems to me to be incongruous. When she goes there, she's going to lose, the trust and respect of her colleagues, members on the Council of State. And people are not going to take her into confidence anymore. And that was why, as a former Chief Justice and presently a member of the Council of State, she ought, to have known that she was treading, an area, that could swallow, her up one day. But, she's very well respected, very eminent, very distinguished. She's entitled to her views, but she has to ask herself But
lawyer, if I may ask also, did she say anything that you felt like she was revealing anything beyond her own opinion on the matter?
The oath of secrecy bars her from opening her mouth.
From granting interviews?
Oath of secrecy bars her from opening her mouth. But that is why the famous said directly or indirectly. It's a governance issue. We must all learn, from our mistakes. Will it be appropriate for any person who has subscribed to the oath of secrecy to come out and comment on matters bordering on the very oath subscribed to? It's a moral question.
Very well. Lawyer, we'll leave it here for now. Kwekwan Sasare is former director of the Ghana School of Law. I've been talking about his position on TV3's interview with the former Chief Justice, Sophia Akuffo, who's also now a member of the Council of State. But let's look at the substantive issues she's raised, including the development with the lawsuit filed at the ECOWAS court. We'll get the thoughts now of Head of Ahmed Legal Consults, Musa Ahmed, on this very thorny issue. Remember that we've told you that the former CJ has taken the matter to the ECOWAS court. Now she's saying, because the government has not responded within the stipulated 30-day period, she wants the ECOWAS court to deliver a default judgment in her favor. Let's check in with Musa at this time. Musa, I appreciate your time with us this afternoon.
We ain't some who team course or journal, so I'm not so jemre wa. That's an so bad, Eddie Adumbi, only a essential na your sumo, constant, a G Politics Avenue.